Thank you. Thank you very much, Professor Gao, for the kind introduction. And it's a great pleasure for me to be here at the Joint Center conference. So I will present work in progress on judicial mediation in China. I will briefly introduce the topic, the methodology, and then just highlight a few key empirical findings and also talk about the theoretical implication. So if we can turn to the next page. So to start with, why the topic? While being essentially policy-driven, judicial mediation has been widely practiced in China without a solid theoretical or institutional framework. But how do the policy shift on judicial mediation over the year impact on the actual judicial practice? And how do the gains of efficiency compare with the possible losses of procedural protection? How do the judge see themselves? What's the role of the judge? Do they see themselves more of dispute resolver of the immediate dispute between the parties, or more of a guardian of justice that transcend the parties? What role do courts and informal justice play in the Chinese society? So there has been a lot of excellent work done on this topic, mostly conducted from the political lens. And certainly the top-down political campaign has had great impact on the operation of the courts and also judicial practice in general. But I would argue in the paper that the judges are not just policy maximizers or mechanical legalists. Judges are human beings. So this research attempts to expand our inquiry beyond the focus of political influence and the role of law, and to examine other factors that could impact judicial behavior, including their personal motivation, their identity, and also cognitive bias, as well as consideration of possible reaction from other relevant actors. So the next page, please. And in order to address those questions, a series of interviews has been conducted with judges from 6 courts in 3 different cities, which are at different geographical location and also at different stage of economic development in order to ensure representativeness of the data. The investigation focused on courts at basic level, but also included judges at intermediate people's level and also some officials from Supreme People's Courts. And the next page, so the chart, as we can see in the next page, will actually show the impact of policy shift towards mediation on the general judicial practice. As we can see in the chart, corresponding to the policy campaign that emphasized mediation since 2003, by mediation during the same. But later, corresponding to the central policy to strengthen the rule of law since 2014, and also a conscious reflection on the mediation heat, we see also that the cases concluded by mediation become more stable, even with a slight drop, whereas adjudicated cases has been on the rise. So all the interviewed judges also felt that the political pressure to push for settlement has been reduced with the policy shift. Although now with the new case registration system and also the judge quota reform, which means now there are less judges to handle increasing amount of cases, so there is also this practical pressure to divert some of the cases to mediation. So the next page will highlight some of the empirical findings. Due to time limit, I will only highlight 1 or 2 findings. The empirical research finds that the judge's preference towards mediation or adjudication are influenced by a number of factors, including their seniority in position, their age, professional competence, social experience, and also include the case laws of the court, nature of a dispute, attitude of the party, etc. So for instance, a high-ranking official of the court tend to have very strong incentive to mediation and for a higher settlement rate, because they will consider the evaluation from higher people's court, which will include a number of indicators, such as appeal rate, remand and overrule rate, and settlement rate. So judicial mediation can provide a kind of safe valve to the courts to reduce the risk of appeal and overrule, and also reduce the petitioning from the parties. But for the ordinary judge, those concerns are less important, and their preference can be influenced by their own aspiration for job security or promotion, which is linked to the appraisal mechanism. And settlement rate is a positive factor in the appraisal mechanism. And now they also included mandatory enforcement rate as a negative factor in order to avoid the settlement inflation. Mediation can also give the judge a sense of honor and achievement, which provides another incentive. The judge preference is also influenced by their personal background. So I find through the interviews, some younger judges who have strong professional competence, many of them have master's degree or even PhD, but maybe less social experience, tend to have stronger preference towards adjudication. And they find it's also easier for them to render a judgment, which typically take half a day for simple cases, than going the back and forth of mediation with the parties. On the other hand, some older judges with substantial social experience, maybe less legal training, but some also have very strong personal charism, tended to have a preference towards mediation. And then the interview also focused on the specific conduct of judicial mediation. One interesting observation is the role of the psychological factors, including the space arrangements. So I observed, for instance, the use of the mediation studio created in some courts to handle the pre-trial mediation, judicial confirmation, and also court referred mediation. So the mediation studio is then separate from the courtroom, and that has important psychological implication. Because in the courtroom, the judges sit above, right? So that represents the authority from the judges. Whereas when the parties are directed to mediation, they come to this mediation studio, and usually the judges, now acting as mediator with the parties, will sit in a round table. So when the space is circular, that will represent that the positions are equal. So that will give the party more comfort. And in some of the mediation studio, there is even tea set. So the judge will invite the parties just to, chat over a tea, talk about their personal feelings before even talking about the case. And I noticed that such a separation of mediation and adjudication space seem to be creating an effective means than those in-trial mediation, because it gives a more relaxed and a trust atmosphere for the parties to really conduct the mediation. And that leads me to the theoretical implications. So if we can skip the next slide and turn to the following one. Yeah, so just to highlight some of the theoretical implications, especially from a comparative law perspective. So the first is the different perception mediation. Right, the notion of ADR in the West, as Alexander mentioned earlier, that could be traced back to Professor Sanders' theory of the multi-door courthouse, raised in the Pound Conference in the 1970s. Mediation is here considered as an alternative to litigation, which offers an informal, flexible, and faster resolution of a dispute. And the core of this idea of ADR is to move access to justice beyond a court-centric approach. However, the concept of mediation in China is very different. Mediation have a very long tradition in China that can be traced back even to the Yao Shun period. But it has always been seen as an integral part of the civil justice system in China, not just as an alternative. So mediation always have the social governance function in China in order to maintain social stability and harmony and preempt the conflicts from escalation. And that has led to then the different perception on the role of judges. The Chinese judges tend to consider their role is not just to sit passively to apply the laws mechanically, but to proactively assist the parties to resolve their dispute in the most appropriate means, which include not just rendering binding and authoritative decision, but include settlement facilitation. So settlement facilitation and decision making are both considered to be their judicial function. And therefore, mediation in China is often conducted by the judges themselves. And if mediations fail, then the same person will shift the head back as a decision maker and render binding judgments. From the interview, we also noticed that the judges seem to also focus on seeking substantive justice in those individual cases, and less attention is paid to the procedural protection. So for instance, if they believe strict application of law based on proven facts could lead to unjust outcome, they might also seek mediation and in order to protect the weaker party and render a substantive justice. Further, the study also shows a cognitive bias on the judge's choices. So regardless of judges' rational goals, whether it's to adhere to the law or the policy or achieving the career ambition, the non-rational factors, such as human sentiment, morality, empathy, also play a role in affecting the judicial behavior. And such cognitive bias is quite common across cultures, but might be particularly obvious in China and considered to be legitimate. In the Chinese saying, a just decision must be fair, reasonable, and in accordance with the law. So law is just one of the factors to be considered, together with fairness and reasonableness. A few judges also acknowledge that human sentiment and their emphasis will have an impact on subsequent proceedings if mediation fails. So for instance, some might go to take initiative to investigate the evidence if they believe that will render substantive justice, and others might also lean towards a weaker party within the restraints of law and their discretion. So when we consider the use of technology in court services, which certainly China is at the front line, and including an increasing adoption of AI tools, blockchain, smart contract in the case management and adjudication process, we should also bear in mind such human sentiment in the decision making. So this human sentiment, I think, just to highlight, perhaps the AI certainly could have a lot of assistance in the court services, but also the limitations in AI in terms of value judgment, human sentiment, human reasoning, and therefore the need to set the boundaries. So now I come to the conclusion, the last page. To conclude, so the research attempt to go beyond the influence of politics and laws in analyzing judicial behavior and propose a combination of different approaches, joining upon the methods in economics, sociology, social psychology, and political economy when we conduct comparative studies. So I conclude to quote Cole Parper's theory of three worlds. The norms and practice of judicial mediation belong to the sphere of world 3, the objective knowledge. And the objective knowledge have its own life, which can develop independently from world 1 of the objective, the physical world, right, like this cup, or the subjective knowledge. So while the states, through the parties, legislature, courts, create the knowledge system, once regulators, rules, policies are made, states do not have control over their future developments, whereas other actors like judges, disciplinary parties, lawyers also play an active role in shaping the norms and practice. So when we study judicial practice, we should also try to understand it from the world 3's objective knowledge that is beyond the control of subjective world. Thank you very much.